and I mentioned it a moment ago, but just to make sure that the foundation is properly laid, we have my clients. If we set aside for a moment, I'm going to ask you to set aside for a moment that my client is just the most amazingly competent protector of his own murder. That, set that aside for a minute, that he didn't just decide as some snap decision to become a murderer and then was perfect in covering up everything. Because I would suggest to you that that is a fallacy of absurd proportions, that such could even be suggested by the state, certainly considered or actually endorsed by you. But if we set that aside for a moment, then what we have to look at is my client, it gets in the altercation with Mr. Martin. After following him to see where he went, as he agreed to with the officer, by not following him after he was told not to by dispatch, and to date, and the state's case is now done, to date, they have not presented any direct evidence, and I would suggest not even circumstantial evidence, that my client followed him after being told not to by the dispatch. They have no direct evidence, no circumstantial evidence that my client ever moved from the T intersection down the dog path until he was drugged or forced there by Trayvon Martin. There's not a scintilla of evidence to support that. There was, it seems, by Miss Bahadur, at some point, though I would suggest it was highly incredible, that she suggested that for the first time she came up with the idea that maybe somebody is moving left to right. I'm sure you recall that. May well have been Trayvon Martin coming back for the attack. We don't know, but to suggest that that somehow inculpates my client to being the one moving is a stretch that I would ask that you could not consider making. It's certainly not one that's supported by any other corroborative facts or evidence. And of course, I think Ms. Bahadur sort of came across, well, let's just say she came across as she came across by the time we were done with her testimony. But aside from that, there was nothing to support that my client did anything to re-engage or to engage Mr. Martin whatsoever. So if we're going to set that foundation, that that is what he did and didn't do, and then see what the foundational evidence is to support that, we have Jenna Lauer. Jeremy Weinberg didn't testify. He was the woman, and so he was the fiancé with Jenna Lauer. But Jenna Lauer testified to something that, again, without my client's knowledge, completely supported what he said and how he said happened at the T intersection. Even Ms. Sudaika, who thought she saw something, and I think thought she heard something a lot different than she saw or heard, through an open window or a closed window, whatever, still supports my client's contention that the altercation began down by the T intersection. Of course, the Manalos also do that as well. So without having the benefit of any of that testimony, we know that my client, of course, gave all that information to both Officers Singleton and Serino at a time when he had no information that any of that was available. Much more importantly, he had no information that any of that was controverted. Because had any of that been controverted, I'm sure that the state will well have brought that out to you before the end of their case. So we have Lauer, we have Sudaika, we have Manalo. We actually even have Mora, who documents my client's hypothesis of innocence or his prima facie case of self-defense. And that is, as she says, when she sort of wandered around the courtroom to look over the column to say that she saw my client on top of Trayvon Martin. A statement that he had already given to Singleton and Serino before he knew that this witness would be able to come out and say he or she saw anything. But he stated exactly what he did, that he moved the hands out. I think giving Dr. Bauer's testimony would certainly support the idea that even having moved the hands out, as Ms. Moore said, the feet still move. Dr. Bauer seemed to say at some point that maybe the body can move, maybe it can't, but nonetheless, this is the foundational evidence for which you have to make a determination. Did my client present to date a prima facie case of self-defense? One, and two, is that prima facie case of self-defense and its reasonable hypothesis of innocence, which is, of course, what it is, specifically contradicted by the state's case. And under Walker, Woods, Barwick, And now, as I've mentioned to you, STIEH, S-T-I-E-H, they have failed to do that. So if we look at STIEH, which is interesting, out of the second DCA, and I don't know that I quoted it, apologize if I have already, 67 Southern 3rd 275, stating that the JOA should have been granted once the defendant had presented a prima facie case of self-defense. And it goes through a pretty good analysis of 776. In that case, they were talking about defense of others, but of course the same standard applies as we have here today. Jenkins, I think, is one of the most instructive cases. That's cited at 942 Southern 2nd 910. The reason why is because Jenkins, a 2006 case, remember, as an aside, that there are not a lot of cases about judgments of acquittal in self-defense cases after 2006. The reason why is, of course, we now have self-defense immunity hearings as an alternative to judgment of acquittal arguments in a trial. We did not avail ourselves of that pretrial determination of immunity. So many other people in most of the other case law have. So you'll see a significant drop-off in the number of JOA arguments or JOA appellate case law after 2006 on a self-defense issue because, as you would imagine, most of them exist pre-trial, they're addressed pre-trial. We had made the voluntary decision not to do that. But Jenkins, what Jenkins is good for, Your Honor, is that, first of all, the facts are close. Jenkins was in his house. A guy was outside making a lot of noise. He went outside. Jenkins did try to minimize the altercation. Cesaro, who was the eventual victim in the case, made a maneuver towards him, punched him in the face, wobbled back, goes Jenkins. Then the assailant comes again. Jenkins takes out a knife, catches him in the heart. He passes away. Jenkins, the case, as opposed to just the facts, is very significant because Jenkins goes through and cites about 7 cases, which is the recent history of judgment of acquittal cases in self-defense cases, judgment of acquittal issues in self-defense cases, and is a pretty good rendition of it. It references, for example, Thompson, which is State versus Thompson, 552, Southern 2nd 24. That's an aggravated battery case where he tried to stop a fight, was attacked, defendant backed up, brandished a gun, aggressor continued to approach, defendant shot him. And that was where the court reversed the conviction on that, suggesting that the judgment of acquittal should have been granted. The Hernandez-Ramos case at 496 Southern 2nd 837, again cited in Jenkins, gives some good insight into a somewhat similar fact scenario. In that case, evidence was there that the defendant took some effort to ward off the attack or end it without violence. The state's witnesses in that case uniformly identified the victim as the aggressor. We have one eyewitness in this case, John Good, I think, would present a scenario very similar to that presented by the state witnesses in Hernandez-Ramos, and that is that we know, and it is completely uncontroverted, that Mr. Martin was the aggressor in that he had mounted Mr. Zimmerman, refused the suggestion by Mr. Good to stop doing what he was doing and continued the attack. Similar to Hernandez-Ramos, the state's witnesses in that case suggested that the victim in the case was the aggressor. And again, that case similarly was suggested that judgment of acquittal should have been granted. Now, that is looking at the issue of the circumstantial evidence and the direct evidence would exist and whether or not my client has presented a prima facie case of self-defense. I think that if you reach that alone, then the case should simply be dismissed presently at judgment of acquittal. As I said a moment ago, I can't say, Judge, can I stop and let you rule, and I'll start over if you don't. So I have to continue as though you're not following my first track, and I'll go to my second track. And the second track is whether or not, should the court not agree that a prima facie case of self-defense has been proven, and that to the extent that circumstantial evidence is being considered by this court as presented by the state, if you decide that that does in fact exclude any possibility of my client, any hypothesis of my client's innocence. If for some reason I've lost those two arguments, which I think the evidence supports that we should win. If we don't, then you have to look at whether or not this case should still move forward on a second-degree murder charge as to the issue of ill will and hatred. So let's talk for a moment about what ill will and hatred is and what it's not. In Light versus State, 841 Southern 2nd, 623, a second DCA case, that was a mosh pit case. Mr. Light didn't like the fact that the eventual victim fell back into him and may have hit him in a sensitive area of his body. So Mr. Light decided to pick him up in a wrestler move, hang him over his head, and smash him to the ground, crushing the left side of his head, I think it was, on the cement. He sort of got up, made it outside, and died. And the court ruled that that behavior, though extremely reckless behavior, to simply get upset at somebody, pick them up over your head, and smash them onto cement, is not ill will or hatred, and would not sustain a second-degree murder conviction, because you can't infer any malice. I don't exactly know how you can infer malice from picking somebody up over their head and smashing them onto cement, but if we were to compare that law, which is now the law in Florida, to this case, I would suggest that there is absolutely no evidence to support the contention that Mrs. Zimmerman acted in ill will, spite, or hatred. If you can get past the expletives, and you get past the fact that he seemed to be particularly interested in his community, and that may have been why he focused on Mr. Martin as a suspicious person, looking unfortunately similar to what we now know we have in evidence of Emmanuel Burgess, who was his one-person crime spree through Retreat View Circle, who got 5 years in prison for his bevy of burglaries in the area. The court may recall that you were the sentencing judge in that case when he came before you about 1.5 years ago. So yeah, an unfortunate circumstance, but that doesn't allow the outrageously over response by Mr. Martin. For sticking to the ill will and hatred argument, basically in the Light case, it was just not ill will because the courts looked to two other cases for the instruction on ill will, spite, and hatred. That being Williams versus State at 764 Southern 2nd, 177, another second DCA case, and McDaniel versus State, 620 Southern 2nd, 1308, a fourth DCA case, to begin the analysis that even extremely reckless behavior itself would be insufficient for you to infer any malice that would suggest second degree. I guess in this case, had Trayvon Martin pushed my client, as happened in the Light case when he actually hit him in the genitals, had Trayvon Martin pushed my client and then my client just reeled back, took out his gun and shot him, under Light, I'm not certain that would have been ill will, malice, and hatred, because the other overriding necessity in an ill will and spite and hatred case, and I know the court is aware, is though second-degree murder for ill will, spite, and hatred, not exclusively, because they'll never say never, but almost always, the people have to know each other. Because the ill will, the spite, the hatred cannot be momentary. It cannot be instantaneous.